Thanks, everybody. Those of you who, there's one or two coming in. If you can find your seat fairly promptly, that would be really good. Thank you. If I may welcome you all here today to Building 98 at RMIT, which hosts the Future Social Service Institute, where I'm acting director at this point in time. RMIT University acknowledges the people of the Woiwurrung and Bunurong language groups of the Eastern Kulin Nations, on whose unceded lands we conduct our business as a university. RMIT respectfully acknowledges the traditional custodians and their ancestors of the lands and waters across Australia where we conduct our business. In that context, and given today's subject matter, we should also recognise that Aboriginal and Torres Strait Islanders with intellectual disability and mental illness are disproportionately represented in the criminal justice system in Victoria. And I think that may be one important emphasis for the ongoing discussion for today. Now, our collaboration with OPA is one that we really value. And OPA, as many of you will know, provides essential services promoting the rights, the dignity, and the interests of people with disability, specifically intellectual impairment, mental illness, brain injury, physical disability, or dementia. When I first visited Melbourne in 1992, I did so in relation to some research I was undertaking around advocacy. Like Melbourne, the UK at the time was trying to resettle people from the large institutions. And as well as hearing about the advocacy and self-advocacy groups here, I also came to know of the Community Visitor Scheme and some of the work that they'd been doing in relation to Kalula and in relation to where people were resettled. It was extraordinary for me to actually find that, unlike the Social Services Inspectorate at the time in the United Kingdom, that there wasn't a 6 to 9 months notice that the inspectorate was going to arrive, but rather that the community visitors had access to and were able to explore issues for people in the places in which they lived. And I think that that scheme continues, and it's an indispensable safeguard, check, and balance on the system. The point I guess I'm making is that through that scheme, things were placed in the light and continue to be placed in the light. And what OPA does, the Office of the Public Advocate, is to place issues like that in the light, to be concerned about the ways in which we treat people with disability, mental illness, and the way in which systemic abuses may actually take place in their lives. So we're very, very happy to be part of this collaboration. And this event is one of many. There will be more which will be advertised for later in the year as well. So on behalf of the Office of the Public Advocate and FSSI, as we call ourselves, Future Social Service Institute, I think it's supposed to jig when I say FSSI, but we welcome you all, and particularly those of you who have come from a long way. Welcome to Disabling Justice, how the system is failing people with disability or a mental illness. Now, one of the things that we share is the idea that co-design and voice drive everything that we do. And so our first speaker today, Justen, will be a voice, an expert by experience. We base our model on co-design, and most of the focus of the Institute, which is a collaboration between VCOS and RMIT, funded by the state government, is around workforce issues. So the things that we will be taking out of today, out of the deliberations, is information which can be fed back both into the workforce, but also into the training that people undertake to establish the values and knowledge and the ways through which we can actually challenge some of the injustices that are presently being experienced by people with disability. Now, just before introducing today's moderator, the Public Advocate, Dr. Colleen Pearce, just a bit of housekeeping. Toilets, both accessible, male and female, are down the corridor. Be careful of the door if you are going further down the corridor. it opens of its own accord. So don't be leaning forward as I was on the first occasion, or you might end up with carpet on your face. The direction of the conveniences is also the direction that you should travel if there is, unlikely, but if there is a fire alarm, and then you will traverse the stairs at the back and meet in the car park outside at the back of the building. At this point, those of you who've got phones, if you might put them on silent or vibrate, that would be really good. And finally, just to let you know that the panel is being filmed, but you are not. And if you have any issues of any sort with that, let us know. But we are aware that if you traverse that during the period of conversation, you may appear in the scenes. So without further ado, I would like to introduce Dr. Colleen Pearce, Victoria's Public Advocate. Colleen has been awarded an honorary doctorate from RMIT, and I'm delighted to hand over to Colleen to moderate today's session and to introduce our fantastic lineup of speakers. So thank you.
Thank you. Thank you very much, Paul. I too would like to begin by paying my respects to the traditional custodians of the land on which we meet, the Wurundjeri people and the Burrung people of the Kulin Nation. I pay my respects to their elders past and present and any other Aboriginal people that are here today. Because we are meeting on our Aboriginal land and because we are talking about the criminal justice system, it's very important that we begin by recognising the overrepresentation of Aboriginal people, Aboriginal and Torres Strait Islander people in the criminal justice system. Aboriginal and Torres Strait Islander people make up roughly around 3% of Australia's population. Yet despite that, 27% of all prisoners in Australia are Aboriginal and Torres Strait Islander. 34% of all female prisoners, Aboriginal and Torres Strait Islander. And appallingly, 54% of juveniles in custody are Aboriginal or Torres Strait Islander. And every year it gets worse. Today we're here to talk about another group of people who are overrepresented in the criminal justice system, and they're people with disability or a mental illness. As Paul said, people with an intellectual disability comprise around 3% of the Victorian prison population. Of those, 25% are Aboriginal or Torres Strait Islander. Prisoners with an ABI in Victoria's prison are 42% of male prisoners have an ABI and 33% of women have an acquired brain injury. A 2015 report identified that 40% of prisoners in Victoria had a mental health condition 2 to 3 times higher than the reported rates in the general community. All of these statistics call into question the fairness and the effectiveness of our criminal justice system, particularly as it relates to people with a disability or a mental illness. Today's forum is very much the beginning of a conversation around why the prison rates for this group are so high and what might be some of the ways in which we can address this issue. It's really the beginning of what I hope is an ongoing dialogue about these very critical issues. Our panellists today are, firstly, Justen Thomas, a disability rights campaigner and a passionate advocate on these issues. Deborah Glass, Victoria's Ombudsman, and Rob Hulls, a former Attorney General, but currently the Director for the Centre for Innovative Justice at RMIT. We're going to start today's presentation with a little video, a very short video, of Justen, Life on the Other Side of Juvenile Justice. In the video, Justen shares his experience to help improve the way our justice system supports people with an intellectual disability. Justen also provides some advice about how young people can avoid getting into trouble. Justen, we appreciate you being here today and sharing this video with you. And a shout out to your support team that's here, the Centre for Intellectual Disability in New South Wales. Thank you.
I've always been a slow learner at school. Even at school, I was always not in a normal class. When you're growing up in an area like this in Campbelltown and all that, it's a troubled area because there's all been drugs and alcohol involved, and of course, for people like me hanging with the wrong people and that, can got me in a lot of trouble and that. I got done for a few offences, just shoplifting matter a second time and all that, and that was a jail term. You're in trouble if you do something and they don't know, or we didn't know disability, but we're punished as a normal person. So there was nothing to resolve the issue apart from locking you up. I needed some supportive stuff, which staff don't know about my medical needs. If I had any advice for juvenile justice staff and court members, is that please understand someone's disability. Let them speak for themselves and not for them. Be patient and listen to them and let them speak. Take your time at it, and it should be like a father and son relationship. Eye contact is important. Showing interest in someone is important. It touches their soul, and very, very important.
Thank you, Justen. I'm really delighted that you're here to talk to us about your experience. And Justen, in the past few years, you've made a couple of videos like this. Can you tell us, just to get the ball rolling, what was the best experience you had in making a video?
Well, My Choice Matters gave me funding to do the video for Advocates Rally. Ben from IDRS put me in touch to get the grant.
And you like speaking to Father Riley because?
Yeah, he's I like his thoughts and how he saves kids on the street. His passion, he's a good role model.
And he helped you think about your time? Reflect on your past?
I was reflecting to it too. Back then, the police would pick on the vulnerable and vulnerable kids all the time. Instability in the house would lead to it being out in the streets and getting the gangs and the drugs. And police pick on you just because you have trauma, and we all know about trauma. I think we learn about it, but it's worse than the person with disability. If I never knew anything about trauma, Father Chris Riley told me about that.
So, Justen, in your experience, what can be done to stop a person with a disability becoming involved in the criminal justice system?
Oh, we all know it all starts off at home and school, and a person needs someone to look out for them when they are neglected or outcast. If something was done when they were young, things would have been better and different. Young people have nothing to do, it's boredom. They start hanging around shopping centres, drinking and sometimes doing drugs. Help kids before they commit crimes, so early intervene. We wouldn't have kids turn to drugs if there weren't social problems happening at home. They need to rehabilitate people. It's a social problem in the first place. It goes back, like I said, it goes back to trauma. You got to talk to and try to communicate with kids. You need disability supports like NDIS, and if there was more support back then, I think half as many wouldn't be in trouble in prison. Law enforcement need to understand about disability that's behind it. There should be changes to loitering laws. The police can tell you to move on, but they understand you've got nowhere to go. Police look at you and make assumptions.
So, Justen, when a person with a disability is involved in the criminal justice system, What should be done to make their experience better?
You should reward kids for good behaviour, not punish them for the bad behaviour. It's better now to have school and education in the system. You need to keep kids active and occupied. Send people at the farms and country towns away from the city. But I need help at court and need a peace court, someone to explain things happening and what you have to do, like you have to do community orders and pre-release papers and
you need help understanding what those things mean.
exactly. People with disability might not know choices are, and you need to actually sit there with them and understand they know they have choices. People with disability should be separated from main people in prison. They should only be people with other disability. I was targeted, I was bashed, and I wasn't helped by officers at the time, and it would have been a lot safer if I only had other people with disability. I was in custody for 18 months, waiting for a hearing. You shouldn't be in custody for that long, even if you weren't found guilty or anything. After that, I didn't trust any public services. You need programs to keep you busy. At Christmas and Easter, it's always a sensitive time of year in juvenile justice. They shouldn't be locked up for long, for a bit, get locked up longer. It's awful. Lockdown should be later than usual. They should have activity games on Christmas Eve. Encourage them to do educational stuff. They should educational games on Good Fridays. Remind them when you notice they're behaving, what they have learnt and what they're going to take away. That way they won't do it again.
So the rules need to be clear and need to be explained, and you need some help understanding what the rules are.
Yeah, more details, yeah. You should be able to talk to someone in one-on-one about their goals and the release, like courses, artwork. The caseworker could help with other ideas. They shouldn't be critical or judgmental and talk about the offence. My recommendation is that, well, we all know this, but Royal Commission in the country.
So Justen, after a person's released, what could be done better to support them so they don't go back in?
Before they go, do some research in the environment and community they're going back into. Check with them about their well-being and their trauma. Something might have happened before they came in. You need someone who shows they care, like Father Chris Riley showed he cared. He always gave us presents on Christmas and Easter, especially fridge full of chocolate milk, flavoured milk. But it was just favourite things, Send them out to farms in the country. It's good in nature. It gives you time away from the city and toxic stuff, bad things in the city. Ben from my DRS is my hero. He included me in lots of things that helped me open up. It helped me see myself more, and I'm going to be a mentor.
A mentor for other people leaving prison.
Yeah.
Yep, fantastic. So Justen, can you tell us about the things that you do to try and make the justice system better for people with a disability?
I run a Facebook page. I do training for staff who work in juvenile justice. I tell them about my experience and give them advice. I have spoken to justice conferences to share my experience with professionals and give my advice in making the system better. I have spoken to members of parliament. I have been involved with a few videos. CRD video about my experience with juvenile justice. A video with IDRS about my experience in Section 32, which is part of the Mental Health Act in New South Wales and allows courts to direct people with disability and other conditions away from the justice system. I also applied for a grant which made a video interviewing Father Chris Riley, who was great help to me when I was young, and as many other young people who have been involved in the justice system. I also have been involved with peer support training, and I now deliver peer support training. I also develop my own workshops.
Fantastic. So you're working really hard to try and make the justice system a better place.
Still a bit more to do yet.
Yeah, there is a lot more to do. Justen, thank you. I really appreciate your bravery and your honesty. It's not easy to talk about your personal life in front of a large group of people, but I think what you do will make a real difference. So thank you very much for sharing your story with us today. If I could move on to you now, Deborah. Nearly 18 months ago, I approached staff in your office about the concerns I had about a 39-year-old woman with a disability who was in prison. She'd been charged with breaching an intervention order, assaulting police. She was found unfit to stand trial and not guilty because of mental impairment. You described this case as the saddest case you've ever seen in your time as Ombudsman. You want to tell us about your investigation and what you found?
Yeah, that's a pretty high bar, actually, in sad cases in my job. And I wish that, we called her Rebecca, not her real name, but I wish that Rebecca was able to tell her story as eloquently as Justen has told his. Sadly, she's not able to, so I will tell a bit of her story for her. Probably good if I give a little bit of background about this, because about her. I mean, this is around about the same time that you approached my office about the experience of this woman who had been locked up for over 18 months, essentially in solitary confinement for that period. We were carrying out an inspection at the Dame Phyllis Frost Centre, so we also encountered this practice of a number of really quite concerning practices of people who were kept in isolation in really distressing circumstances. So to tell you a bit about Rebecca, as we called her, she had what describes as behaviours of concern from a very early age. So she had a troubled childhood. She had trouble socialising with other children. She had trouble at school. She had general trouble with her behaviours. She left school in year 8. And experts had also had trouble diagnosing the problem. So in her case, people couldn't agree what the issue was. What was the diagnosis? Did she have a mental health problem? Did she have disability? And it was, I think, that part of the problem was this inability to come up with a diagnosis, and fundamentally, she became the victim of the inability of professionals to identify and provide appropriate levels of services. And I just want to come up with some of the details that we had in our report. I mean, she had complex behaviours, and there were reports of verbal abuse and physical abuse. She would, assault teachers and other children, her family. Very complex. So from her teens through to her around her early 30s, she actually got services through the mental health system. And she spent some time in secure wards and care and community housing. But when she was 34, she was given a new diagnosis of pervasive development disorder, which is on the autism spectrum, as I understand. So she then comes under the disability system. So what happens then is that the mental health services say, well, you're no longer a mental health person, so we can't provide you with services. So it's now the problem of the disability service sector to look after you. Now, because the mental health system is for treatable illnesses, and what the experts were now saying, you don't have a treatable condition, therefore you have a disability, therefore you belong in this system. But, and here for people with an intellectual disability, it has to be diagnosed before the age of 18. Otherwise, you haven't actually officially got an intellectual disability. So the disability services then wouldn't provide her with appropriate services because she didn't meet their criteria. So here you have a highly vulnerable person who fell into a service gap. And that fundamentally is what led to her landing up in prison for over 18 months. So there was a history of family violence intervention orders. And one of the things that was so sad about this case is, here is a young woman who obviously wanted to connect with her family, had difficulty doing that. Her family, she was, assaulting members of her family. They were taking out intervention orders against her. She didn't understand those orders. She kept going home. They kept calling the police. So it was a particularly sad scenario. So, she couldn't go near her family, but there was nowhere else for her to go. So she was being remanded and released, for pretty constantly from about the time she was supposedly dealt with by the disability system. And there are instances where she was being released with a Myki card and sent out of the streets with nowhere to go. And another instance where she was given 2 nights of crisis accommodation. So what was happening, of course, was that she was going back into prison, back, out, in and out and in and out. Finally, she's remanded to prison on she's charged with breaching an order and assaulting police. And she is found unfit to stand trial, which she plainly was. Now, we have some pretty complicated laws in Victoria around unfitness to stand trial, and it's, the Crime is Mentally Impairment and Unfitness to be Tried Act, where the judge has a limited number of options about what to do with somebody who is unfit to stand trial. They can send somebody to the Forensic Mental Health Hospital, Thomas Embling. There is one such institution in Victoria. Now, that wasn't suitable for Rebecca because she doesn't have a mental illness, so they wouldn't take her. There are some DHHS-operated facilities, again, not suitable. One of them is for male sex offenders, so it's again, plainly unsuitable. And the alternative is the prison system. And that's where she went. So she's remanded, basically, she is in Dame Phyllis Frost, and she is in, this is the Marmac unit that you can see on the screen behind you. And she basically stayed there because there was nowhere else for her to go. Now, the judge in her case had said that if she had, and this was commented on, if she had actually been fit to stand trial and pleaded guilty, she probably wouldn't have got a custodial sentence at all. So here she is for over 18 months.
So you've already said that 18 months, she spent part of that time in solitary confinement, and that obviously had a significant impact on her well-being.
She spent almost all of that time in solitary confinement. She would scream for hours on end in a single cell, and I think I've got some photos of that. This is Rebecca's cell. It actually didn't have, at the time she was in, it didn't have a television. That was taken afterwards. She was allowed out for what they called airings for an hour a day. Now the problem was, and I actually understand the dilemma from the standpoint of the prison. Her behaviours were such that she was a danger to herself, to other prisoners, and to staff. She would spit at people. She would assault people. She was in danger from other prisoners as well. So it was a particularly difficult situation that she was in, and it was plainly not an incredibly challenging environment for her. And I mean, this is. I think we've got some photos of the. So these are the surrounds. So for an hour a day, she, if she was lucky, she would get what they called an airing, but she often didn't get those either because they were inconsistent and her behaviour was quite. If her behaviour is what they describe as elevated, then she stayed in her cell.
And there is an obligation, both under the Charter and the Equal Opportunity Act, to provide reasonable adjustments. Were any reasonable adjustments made to her in those circumstances?
Well, I mean, let's just start with her human rights. This is a complicated question. Did this breach her human rights? Without a shadow of a doubt, it did. The state has an obligation to provide. When people are deprived of their liberty, they must be treated humanely. There is an obligation for humane treatment when deprived of liberty. There's a prohibition against cruel, inhuman and degrading treatment. Now, there was Rebecca in her cell, unfit to stand trial, where she was deprived of human contact, essentially, for 18 months.
Pretty appalling circumstances.
Absolutely. So the Nelson Mandela rules, for those who are familiar with those, define solitary confinement as 15 continuous days of being locked up for 22 hours or more. Now that's 15 days. In her case, we're talking over 18 months. So significant breaches of international treaty obligations, but it was complicated. When we looked at it, and I remember when we were looking at the end of this report, and here, available if online for all those interested, what these breaches were. I mean, one of the complicated factors, there were a lot of people in prison who really tried to do their best for her. The prison didn't want her there. They knew that she was much too complex a prisoner. They could not deal with her. They weren't in a position to treat her. There was a prison. They weren't disability workers. They were prison officers. But there were things that could have been done. They could have brought in behavioural positive support programs. Justen, I think you touched on that. And they could have found her somewhere to go much sooner. One of the problems that we saw was that they would have all these case conferences about, there were weekly, sometimes weekly, at least monthly, there would be a case conference, where all people from agencies would gather to discuss the problem of Rebecca and what they needed to do with her. And we looked at the minutes of these conferences, and where it said responsibility, they would say all. Now that I can tell you, and for any of you who are working in the public sector, that is a recipe for nobody taking responsibility. So when everybody has responsibility, no one does. So the fact that no individual agency, it was all, somebody else needed to deal with this complex problem. And so lots of well-meaning people who acknowledged the problem but didn't grip it.
Yeah.
And also it goes back to misdiagnosed can be fatal. And obviously that's what's happened.
Yeah. That's right, and I think the other aspect of your report is that Rebecca's wasn't an isolated case.
No.
I'm not talking about one person.
No, and that was a really important issue we wanted to look at. So yes, we wanted to investigate the specific problem of Rebecca, but we also asked the question, who else is out there who might be in a similar position? Is it just, one single, highly disadvantaged, vulnerable woman, or are there more? Now, we couldn't even get an answer to that question because no single agency is responsible for monitoring those people who are not fit to stand trial. So anecdotally, we got a lot of, and here we are actually, there's that's from the report, examples of actually newspaper stories that illustrate this problem. Victoria Legal Aid gave us evidence about the numbers of their clients who had been found unfit to stand trial and what happened to them. So we had anecdotal information about this happening across the system, but I can't tell you how widespread it is because nobody takes responsibility for that and nobody pulls this kind of information together.
And I think a key to that is the assessments of disability. And you did another very significant report, the investigation into the rehabilitation and reintegration of prisoners in 2015, and you identified the failure to assess a prisoner's acquired brain injury as a critical factor, and you made recommendations around that. Have we seen the introduction of assessments around disability in prisons?
Not yet. However, I do follow up on my recommendations, by the way. So, for those of you who think Ombudsman's reports gather dust, not only am I happy to see that one of my reports is in the hands of, the next speaker, but I follow up. And I did make recommendations about a number of, 25 of them, in fact, in 2015. And one of them was about introducing a screening tool for cognitive disability. I mean, what we're mindful of is, when somebody goes into prison, they're being dealt with by prison officers. Prison officers might have some modest training in mental health or disability, but they're fundamentally not trained health workers, are they? So there isn't one of my key recommendations was around secure therapeutic facilities in Victoria, which we simply don't have. But more broadly across the prison system, identifying who needs this kind of facility or not. What we were told, and I think I can quote you from this one, it's in progress. Corrections has selected a screening tool but needs funding to roll it out. And the last advice we had, because we are actually actively following up, is they're submitting a bid in the next budget, the 1920 budget. So I will be asking the question, and you may ask it too actually, Rob, whether they get the funding they need to roll out this screening tool for cognitive disability right across the prison system in Victoria.
Deborah, there's lots of other questions we could ask, and we could just spend a forum just on these issues, but I'm going to move on to Rob. And Rob, a little while ago I had cause to look at the very first OPA annual report. That report in 1988 identified there were over 3,500 mental health beds in the state. We then had a period of rapid deinstitutionalisation, and it's very hard to work out how many beds there are in the system now because it's just not readily available. But I think there's around 500 acute beds, about 350 subacute beds, and a kind of patchwork of community mental health services. Rob, did we get the balance right?
First of all, don't blame me. I'm not in Parliament anymore. I just know that. Deinstitutionalisation was the right policy, had to be followed up with funding. And if you don't follow it up with funding, you're going to get to the situation where, by and large, we've got to now, where our prisons are 21st century asylums. Like that's the reality. We are warehousing people with mental health issues, with acquired brain injury issues, with alcohol and other drug issues in our prisons. And it's just not working. It's not making us safer as a community. And if you don't believe me, read Deborah's report in relation to the investigation into the rehabilitation and reintegration of prisoners, where she makes it quite clear we keep going down this path, we're going to end up spending more money on prison beds than hospital beds or school classrooms. Is that what we want as a community? I always find it fascinating, Colleen, when we watch the news at night time. And we have the utmost sympathy for a victim walking out of court. A victim may have lost their son in a culpable driving matter or whatever, and the victim straight away has a microphone put under their chin and they're asked, are you satisfied with the sentence? And always the victim says, no, all he got was 8 years. What the journos never say is, well, if 8's not enough, what is enough? Is 10 enough? Is 12 enough? No, what they want is their son to come back. The justice system can't deliver that. But we have the utmost sympathy for them when they are walking out of court as a victim, and we understand their pain. We think, at least, we understand their pain. But then as a result of being a victim, they fall into drug and alcohol abuse, have mental health issues, homelessness issues, long-term unemployment issues, and then might cross over the line and come into contact with the justice system as a perpetrator themselves. We have this sympathy bypass as a community where we say, oh, bugger them, lock them up and throw away the key. And that's what we're doing as a community, because our jails are full of those type of people. Like the majority, 80+% of women in our prisons have been victims of sexual assault or family violence. And we're jailing these people. As you've already cited, 42% of men and 33% of women in our prisons have an acquired brain injury, compared to 2% in the general population. We're warehousing them in our prisons without any support mechanisms. So jails are our 21st century asylums, and if we keep going down this path as a community, we have to make a decision. Do we want to continue to spend more money on prison beds, or do we want to actually reinvest that money and think in a much smarter way to put wraparound services around these people so we don't have to continue to build more prisons?
You talk a lot about justice reinvestment. I don't know if everyone understands what that is. And Deborah, you made some very important recommendations around that in your 2015 report. But Rob, what is justice reinvestment? What do you hope to get out of it?
Well, basically, it's about taking the money out of the huge amounts of money we're spending on jail beds and reinvesting it in early intervention programs, in support services, in community corrections programs. It was trialled in the most notorious place it was trialled in was in Texas, actually, under the former Governor Jeb Bush. Not a left-wing ratto by any stretch of the imagination, but he decided that when he came to office, he got his Treasury officials in and said, look, we're going to go broke as a community if we keep spending so much money on prison beds. I want you to reinvest that money in early intervention programs and let's do an assessment and see if it works. And they saved so much money, they were able to, as I understand it, close 3 prisons through the savings. Like, this stuff actually works. There's trials taking place in Burke in New South Wales, and reinvesting that money and putting holistic supports around people, like as Justen said, in the earlier years, will save you a fortune in the long run, because let's not kid ourselves, prisons are really, really expensive to build, really expensive to maintain, and ultimately people come out of prison when they've done their sentence, and we're not making ourselves safer as a community if we're not putting appropriate support networks around these people. And currently, we're not. Justice reinvestment is absolutely the way to go.
And Deborah, what's the response to your recommendations that government invest in some small programs in disadvantaged communities?
Look, it's been pretty good. You know, when I put out that report in 2015, that I'm still monitoring, of the 25 recommendations, they were all either accepted, in principle or in practice. And for me, accepted in principle isn't good enough. You know, the particular, what we have seen that I think has improved, we've seen investment in diversion, we've seen a increase, we've seen a growth in the diversionary court system, alcohol and drug courts, another Koori court, for example, again, really important.
Some innovative Attorney General.
Yes, I realised when I put my report that all the things I was recommending that as pilots expand were actually done by some former innovative Attorney General. But he did point that out to me when we started the panels. Because rhetorically asked the question, there was a single drug court in Dandenong when we did the report. It was Dandenong the only place in Victoria with a drug problem. I don't think so. So what we have seen are expansion of courts. We have seen some justice reinvestment initiatives on a pilot basis. And interestingly, because I'm also following up on this, we had been seeing a marked increase in the recidivism rate, and it hasn't improved, but it's flattened out. So I think you can actually draw some parallel between those programs and the rate of recidivism. One of the biggest challenges, though, in the prison system is actually the increase in remand prisoners, because that is a particularly difficult cohort for prisons themselves to deal with. These are unsentenced prisoners, many of whom have significant mental health problems, disability, ABI, drug and alcohol concerns, which in a very unsettled environment where they're not, they don't even know whether they're going to be there for days or months or years.
And it's dead time. Like, people who are put in prison on remand, waiting for their matter to be heard, don't get access to any programs. So, or any appropriate programs.
Actually, slightly since the report.
Yeah, but not in, as they do in the mainstream prison. So it's dead time. Like, it's just wasted time. And often these people, when they finally end up going to court, don't get any extra time. It is wasted time. And of course, always around election time, politicians like to stand on the front steps of Parliament House with their, law and order baseball bat and say, vote for me because mine's bigger than yours. And as a result, at the last election, we saw the most vitriolic law and order debate that I've ever seen as a member of this community. And, you know, politicians promising that we're going to be tough. No, we're going to be tougher. No, we're going to be much tougher. Oh, we're going to introduce mandatory sentencing. Oh, no, we're going to whip them before we mandatory sentence them. Like all that sort of stuff. It just doesn't work. We just have to think much smarter as a community, and, you know, far more stringent bail laws and the like means more and more people are being locked up on remand, and that's costing us enormously as a community. I mean, we did a project recently. I'll just be really brief on this, Colleen, but a young kid, restorative justice. We're involved in restorative justice at the Centre for Innovative Justice, and a young kid, culpable driving, killed somebody whilst he was on drugs and alcohol. He's in jail. He got 4 years. He got 6 years with a minimum of 4. We were able to bring together the sister of the person that he killed and him in jail in a restorative environment, right? It was the most extraordinary thing where at the end of the conference, she's agreed to mentor him when he comes out of jail. He's agreed to volunteer at the same organisations that the man he killed volunteered at in his memory. But she, importantly for this conversation, has agreed to be an advocate for prison reform because she found out when this kid went into jail, he actually tried to enrol in an alcohol and drug rehabilitation program, wasn't able to get access to that program. As a result, he won't get parole because he hasn't done the program. As a result, he'll do his full 6 years and then he'll be released into the community without any supervision and without undertaking a drug and alcohol rehabilitation program. How on earth does that make us safer as a community? It doesn't.
Rob, you've done some other programs in this area. Do you want to talk just a little bit about some of the other initiatives?
Yeah, we've done a big body of work in relation to people with acquired brain injury in the prison system, and we produced a report to government called Recognition, Respect and Support, where we actually put together a group of people who have an acquired brain injury who have been, a bit like Justen, been involved in the justice system and the prison system, and we got their views about how to change the system and how the system would be much better for them. We made 35 recommendations to government, and we're hoping the government is seriously considering these recommendations. But we're also now, as a result of this work, embarked upon a supporting justice project where it's a continuation of our initial project looking at ways to improve the justice system for people with cognitive impairments. And we will be putting together users of the system. We're negotiating with all stakeholders within the justice system, and I urge people in this room to get involved in this project. If you're fair income about wanting to have a much better system that deals more holistically with people who have cognitive impairments, who have disabilities, the project we're embarked upon is the way to have some input, as is, the stars are aligning at the moment, as is the Mental Health Royal Commission. Like, let's not kid ourselves that other people should be making submissions to the Royal Commission. It's not up to us. It's up to everyone in this room. The government has said that it is going to implement each and every one of the recommendations of the Royal Commission into mental health, and there is a specific term of reference in that Royal Commission that touches on the intersection between cognitive impairment, mental health issues and the justice system. And it's important that people have a look at that and make a submission to the Mental Health Royal Commission if you really want to make a difference.
So, Rob, that's a call to action for the audience. Anything else? Any other ways that the people here can do something?
Yeah, I think it's really important that we listen to people like Justen, that we listen to people who are users of the system. You know, I've said this previously, if there was a trip advisor, you know, for the justice system, it'd get no stars. You know, it's a system designed usually by lawyers and judicial officers for lawyers and judicial officers, and they don't take any account or much account of the customer, of the users of the system. And the users of the system have some great answers, some great solutions. So my advice is to speak to people who use the system, whether they be ex-prisoners, current prisoners, people with an acquired brain injury, people who've had contact with the justice system. They'll tell you not only how the system does not improve their lives, actually pushes them further into the mire, but they will have a whole range of solutions that policymakers need to take on board in a serious way.
And also going back to saying that is that, well, I said, I'm going back to trauma. Some can have quite brain damage from trauma, and that's not going to solve the issue, you know what I mean? It depends on the development of the trauma.
Justin, you talk a lot about trauma and the importance of that in both offending, but the fact that nobody ever spoke to you about trauma. It wasn't until Father Riley started to talk to you about it that you understood.
It made me reflect a lot. It's good reflecting, and I mean, most of us here, we all go home every afternoon reflecting on things and what things need to be changed.
And your discussion. So having somebody who listened to you and talked to you about your experience really helped you understand what were some of the causes of your offending.
That's right.
Yeah. So we need more people in the system, just as Rob said, who listen to people like you and understand what it is you need and what you want.
Yep.
Deborah, you've done a number of reports now.
Yes,
on the
probably haven't done the last of them actually on the prison system.
But what would your advice be to the people in the audience? What are some of the ways that you think this group, if they're serious about wanting to address this issue, what can they do?
Well, I think one of the things that I think is worth, two things actually worth identifying. One is that stories resonate. And I mean, just as Justin's story resonated, I'm sure, with everybody, Rebecca's story resonated when we published that report.
Dylan Voller.
Yeah, I mean, yes, indeed. Yeah, we can talk, in general terms about breaches of human rights, but actually, that isn't going to get any traction. Talking about a specific case where something really bad happened to somebody that shouldn't have happened, that we can all relate to and think, what if this were my son, daughter, neighbour, friend? How would I feel about that? So there's something for me about identifying stories that tell that have impact, and including the story you've just told, Rob. I think that's a really powerful one, because you've got to reverse the psychology that locking people up and throwing away the key works, because it doesn't. So I mean, I have these arguments all the time. When I put that report out, with some parts of the press, and you can turn this around. You can challenge it. And you need to challenge it with stories and evidence. So I think that for me is some of it. And the other thing I think is actually pushing the economic argument, because that works with the what I might describe as the non-human rights element of the community. It actually it's going to cost us a lot. I mean, what I don't think it was human rights that made Jeb Bush bring in justice reinvestment in Texas.
No, that's right. And when I took things like the Neighbourhood Justice Centre to my cabinet colleagues, and we don't talk about what happens in cabinet, but you'd like to think it was the social justice running through their veins that decided this holistic approach was going to work and appropriate. I suspect some of them thought this is another namby-pamby, Halsey, lefty idea, until I was able to show them for each dollar you invest at that front end in holistic services, you save $2.35 down the track or $4 down the track or whatever it was. Their eyes lit up and thought, oh, that's money that can come into my portfolio. Yeah, let's support this. This is a great idea. So Deborah's right. The economic evaluation of some of these initiatives is absolutely crucial.
I'm going to shortly open this discussion up for questions, but Justin, you wanted to ask a question? You wanted to ask Rob a question about fines?
In New South Wales, as you see, I speak to everyone here, is that they used to lock people up here, and they do it here, but in New South Wales until one day in the prison system in New South Wales, a guy was bashed severe from not paying the fine, but he was locked up. He was bashed severe that led to his disability. Now, there's a big outcry, human rights thing, and that's where New South Wales government got together and decided not to lock people up for fines anymore. Instead, what they've done is it reflects on the RTA services and all that. They'll cut your services off until you paid that fine instead of,
So your question for Rob was, are we doing that in Victoria?
Yeah, exactly.
People still being jailed in Victoria for non-payment of fines.
Yeah, you can get jailed in Victoria for non-payment of fines. There are special circumstances lists established in the Magistrates Court where you can actually make an application to have all your fines waived if you can show special circumstances. It is a fairly complex task to do that, but yes, there are certain lists within the Magistrates Court where you can have your fines waived depending on your personal circumstances. But in Victoria, you can still be jailed for non-payment of fines. And I think it used to be about $100 a day. So, you know, if you owe $101, you could be jailed for 2 days. But, you know, I repeat, there are lists where people can apply to have those fines waived.
And there's a very big campaign underway in Western Australia at the moment.
There is, in particularly in relation to Aboriginal women who, as Justen has explained, many of them are being locked up and being abused in prison, and they're being locked up because they're poor. You know, they get fines, they simply can't pay them. And so, you know, we're criminalising poverty. And a big campaign in Western Australia where funds are being raised to pay off those fines to get those women out of jail. You know, we still criminalise homelessness here in Victoria. And if you go to New Zealand, you have a look at what they call the Court of New Beginnings in New Zealand. It's a specialist court for homeless people, where people who are committing offences and being brought before the justice system because of their homelessness, the court acts as an oversight of all the support services and direct support services to those people, to find them accommodation, to find them assistance for their drug and alcohol addiction, to find them assistance for a whole range of mental health and cognitive impairment issues. Courts can be used to provide these wraparound services, and judicial officers and judicial monitoring can be used not just to check up on them on a regular basis, but to hold the services to account, which is a pretty good thing.
I think, Rob, one of the things that we're seeing in my office is one of the biggest single factors affecting people with disability and mental illness in contact with the criminal justice system is the lack of access to accommodation. And in Rebecca's case, part of the reason she was there was not just access to support services, is where would she live? So part of the solution has to be, when you're talking about homelessness, is about where can people live? There are just simply inadequate places. We are seeing more and more people placed in insecure accommodation like Quest apartments or emergency crisis accommodation with no long-term plan about where they can live.
Oh, I agree. And you know, I know that magistrates have difficult jobs to do, trying to get the services together to assist with that accommodation. I know, for instance, that many of the magistrates out at Broadmeadows, for instance, thought they were doing the right thing by people who were coming before their court who didn't have a roof over their head, and they were referring them, at least for a couple of nights, to a place called the Coburg Motor Inn, for instance, until a couple of the magistrates actually went out and had a look at it and decided we will never, ever refer somebody to the Coburg Motor Inn again. It was worse for them and more dangerous for them to go to a place like that than not have a roof over their head. So it's not just accommodation, it's appropriate accommodation that needs to be provided.
I think one of the things that's come out of the discussion for me is the key issue of early intervention and prevention. Starting young, that was really one of the big themes coming out of your talk, but also then leaving prison, leaving prison, appropriate supports for a person's disability and mental illness. And I think part of that is the NDIS system. And I'm going to be terribly mean, and I can see Jerry there in the audience. Jerry, can I ask you a question about NDIS and mental health and something about your role? And having listened to this discussion, what do you think we could do to, what can NDIS do to help the people that we're talking about?
Hi, Jerry.
And sorry to put you on the spot, Jerry. I spotted you there. Perhaps you should tell us who you are.
Thank you, Colleen. Good morning, everybody. Jerry Norton is my name. I'm the Strategic Advisor on Mental Health for the National Disability Insurance Agency and have a long background in working in community mental health services in Victoria. I was interested to come along to today's forum to hear the sort of issues. And I suppose the first thing I would say is the NDIS as a scheme clearly some of the people that we are talking about today are clearly likely to fit into the eligibility criteria for the National Disability Insurance Scheme. And I think it's really important when we start to think about the problems, and we've spoken about money, that the state government and the Commonwealth government are committing what will be, at full scheme, $650 million specifically in relation to psychosocial disability or mental health issues. So one of the messages I bring is, excuse me, there is some significant new money that will come into the system through the NDIS. One of the issues that we do face is how we understand what we call at the moment the mainstream interface issues, and how does the Commonwealth work with the Victorian government and with Victorian agencies in thinking about a more integrated approach. And one of the issues I think that is increasingly clear, we've had NDIS designed perhaps from a distinct tradition of thinking, and we've got starting to understand that we do have a whole set of intersections that we need to find working solutions for. Interestingly, I'm meeting today with the Victorian and ACT government, specifically talking about how we're going to progress this issue. So just to say, without going into too much detail, for me, the sort of issues that are being raised here are of real concern to the NDIS. There's a lot of work starting to occur in this sort of space. I share Colleen's comment that clearly accommodation is one of the major issues we sort of face, and there are major demands on the scheme in relation to accommodation. But I think the comment I make is this is an important dialogue that needs to continue with Victorian government and with the National Disability Insurance Agency as we progress this rollout of the National Disability Insurance Scheme that I think does offer, it is, I think, the big source of additional funding to address some of these issues. And I think there's clearly strong national and strong Victorian government commitment to that.
Thanks, Jerry. Very helpful. Patrick, I think you wanted to ask a question.
Thanks, Terry.
And Patrick, could you say who you are, where you're from?
My name is Patrick McGee and I'm from the Australian Federation of Disability Organisations. Justen, I was hoping to ask you a question, but before I do that, I just wanted to say how important it is to have yourself on the stage alongside the Ombudsman and the Director of Innovative Justice and the Public Advocate. The contribution that you're making to this wider conversation is the missing bit of the puzzle, because my experience tells me that the answers actually lie from within the person who's experiencing the system. And we haven't been very good at putting people like yourself onto the stage and into the spotlight and listening to you. And I hope that we do get better at that. And I think you spoke incredibly well. So thank you very much. I wondered if you could tell me, when you were experiencing the trouble that you referenced in Campbelltown, what would have stopped you or sent you in a different direction? What support would have you liked to have received that would have stopped you from going to jail? Does that make sense to you? Like, what was it that was missing that you needed at that time to stop you going to jail?
I always found myself that I had no guidance, I had no role model, apart from Father Chris Riley, but actually, as regards to after release from prison, what will stop me is that in my misdiagnosed, it goes back then, my disability back then too, and a lot of things that the services, and if they had good services back then in regards like they do today with NDIS and CID and all the disability services, I wouldn't have been, a repeat offender. May have had my treatment and go to peace court meetings and that instead.
So, Justen, were you, when you were at Campbelltown, were you living at home? Or
As regards that was a fractured. I was living at home at Campbelltown. That was a fractured home. Had a fractured family which tore apart, and gradually my brother moved to Perth, and there's a lot of instability at home, fractured at home.
and not supports for the family, and
I had no
especially for
support,
you.
and I had to find my own 2 feet. But at one stage I went from home. I went to my grandparents for a little bit, but then that led to me being on the streets, and then me being on the streets, it led me hanging around with other so-called people and doing stupid things, and realised that, you know.
And ending up in juvenile justice.
And then went from juvenile justice up to the teenage to adult. So it's very serious, yeah.
Yeah. Well, I think, you know, time and time again, it's this issue of early intervention and prevention and what we need to do. And part of the restorative or justice reinvestment initiatives you talk about are working with families, investing that money in family supports so that we do try and make sure young people do have the supports they need at an early enough age. So they
and also keep checking in with that person, you know, on the outside as well, not just in prison, but outside. Keep checking in their well-being.
follow up.
And governments have to have the guts to do this. And we have to give governments the guts and the imprimatur to do it. Often governments look for short-term quick fixes. Justice reinvestment is a long-term program. Right? It doesn't happen overnight. So we as a community have to give the imprimatur to governments to ensure they go down this path if we really want to make a long-term difference.
Other questions? Yes. And if you could say your name and where you're from.
My name's Bryn Paulson. I'm from VCOS. I just wanted to get the panel's views on the Queensland Productivity Commission report that's come out, and even our friends at the IPA who've recommended changes to the Crimes Act or the Criminal Code in jurisdictions. Is it time to rethink what constitutes an offence that channels someone into the criminal justice system rather than thinking about people's actions and health or other responses?
For you, I think, Rob.
I'm not sure what you mean by the question. Can you just expand on the question?
So the Productivity Commission in Queensland's recommended that the Crimes Act be reviewed in Queensland so that crimes that people experiencing disadvantage predominantly are overrepresented in, shoplifting, loitering, public drunkenness. Is it time for Victoria to have a look at the criminal code as well? So rather than dealing with a public drunkenness, a loitering offence through a criminal pathway, that we start rethinking the ways that we actually even think about these actions?
Sure. Yes, it is. Unless you reform, you go backwards in any area of life, and the justice system is no different. Unless you continue to reform, you know, if someone came down from Mars tomorrow and walked into our hospital system now, as opposed to them coming down 100 years ago, they wouldn't recognise our hospital system, the innovations that have taken place. If they came down 100 years ago and then came down today and walked into our courts, they'd think, oh yeah, it's just the same. Yeah, blokes wearing horse hair on their head. Yeah, it's all the same. Not much has changed. And I think that unless we continue to innovate, we go backwards. And you know, homosexuality was against the law not too long ago. You know, we've been enlightened enough to review that legislation, and it's no longer a crime. Things like homelessness, public drunkenness, like the Royal Commission into Aboriginal Deaths in Custody that I was involved in as a young lawyer many years ago up in North Queensland, recommended decriminalisation of public drunkenness. It's still on the statute books in many jurisdictions, including here. You know, lock people up for being drunk. I agree. You just have to look at many of these offences in a different lens, and it is far better and far more cost effective for a community to look at the underlying causes of why people come into contact with the justice system. You know, as Attorney General, I always took a pretty simple view, a bit like me, that you know, people's lives go along a certain track, and sometimes they'll have their ups in their lives. You know, they might win Tats Lotto, they might get married, have kids, and sometimes they'll have lows in their lives. You know, they might lose their job, they might have mental health issues, there could be a death in the family, and they'll, at that stage in their life, touch the justice system. The justice system, at that point in their lives, can either push them further into the quagmire of disadvantage, or can act as a trampoline and bounce their lives back on track. And I always took the view that that contact with the justice system is a specific, special moment in their lives where the justice system can be used to get their lives back on track. Hence the holistic, therapeutic, restorative courts that I introduced. They've all been independently assessed. They work. That is the way of the future, trying to address the underlying causes of why people come into contact with the justice system and deal with that in a holistic way.
Paul.
Oh, hello, Paul Ramcharan again from the Future Social Service Institute. I was just interested in whether or not you thought that the implementation of OPCAT would make any difference, given that justice reinvestment is going to take some time, and if so, what advice you might give to those who are implementing it.
Is that you or me?
Could be either of us. I think. I'm happy to.
I think it's you first.
Does anyone know what OPCAT is? Before, to answer that question, the Optional Protocol of the Convention Against Torture. It's a UN treaty that Australia signed up to finally about a year ago, and what it will require. It's a very unusual for a UN treaty. It's a very practical treaty because it requires all parts of Australia to open up their closed environments to independent inspection. So it's intended to be preventative. It's intended to look at improving the system to ensure compliance with this really important treaty, which is about inhuman and degrading treatment. So in practical terms, it will require Victoria to have designated bodies who have the right level of independence and powers and ability to report publicly, to go into prisons and to report on what they see and to, one would hope, help to improve the system. So yes, absolutely, I think it's a good thing. In fact, we first came across the sad case of Rebecca when we did an OPCAT compliant style inspection at Dame Phyllis Frost, the women's prison. So we were, there was a whole team of ombudsman officers in the prison for a week, from morning till night, looking at how everything was working out, what was going on, and there we found, numbers of women who were being locked up for long periods. So yes, OPCAT has a really practical effect to identify potential abuses, to bring them to the attention of the system and to public notice, and to make sure these things don't happen again. I mean, if there had been OPCAT in the Northern Territory, we would not have seen the Dondale abuses. I am really sure about that. So what it does is that it puts the system on notice that people are going to come in there and keep an eye on things.
I couldn't agree more. I mean, the fact of depriving a person of their liberty is extreme punishment in any community. For them to be treated in an inhumane or degrading way whilst in prison is just not acceptable. And there should be regular Human Rights Charter compliance reviews taking place. We have a Human Rights Charter in Victoria taking place in Victoria, and OPCAT is a way of ensuring that anybody who's held in a confined space can have independent assessment in relation to the way they're being treated.
I note that the ACT has just released a paper on the human rights principles for prisons, and I think that's a paper you've seen, Deborah. I thought it was fantastic, and it is a way of holding prisons publicly accountable for the human rights, but we don't have anything like that in Victoria.
Well, we actually have a lot of tools, and I should acknowledge that the author of the Charter of Human Rights is sitting next to me. Like,
Took you a while.
with all the other enlightened developments in our justice system over the last 10 or so years, and it is a great thing that Victoria has a charter. I mean, Queensland is about to introduce one. ACT has one, but Victoria is still the only state in Australia with a human rights charter, and what that allows us to do. So when we did the inspection at the women's prison, when we're doing inspections and looking at the experience of young people in isolation across the system, which is my second OPCAT investigation, which is ongoing, we use all of these different principles. We'll use the Nelson Mandela rules. We'll use the Charter. We'll look at international standards. And we'll put all of those things together to come up with some practical aid memoirs for what does good practice look like. So it's not just some sort of rather airy concept that isn't real. It's about what actually should be going on inside our prison system.
John, you had a question?
John Chesterman, Office of the Public Advocate. A question probably for Rob, but I'm interested in others' thoughts. Of course, early intervention is very important. At the same time, it seems judges need more options when it comes to actually sentencing someone who's been found guilty. And one, as Rob and Deborah mentioned, people with acquired brain injuries in prison at a rate for men 20 times that of the general population is just extraordinary when you think about it. One idea that's been circulating that I know, Rob, one of your colleagues, Stan, who's here and I've talked about, and is circulating is an idea that for people with acquired brain injuries, there could be an option for judges and magistrates for referral to a supported accommodation kind of setting. Your thoughts on that idea, but also how do you get political, in a way you've kind of already addressed this, but how do you get political traction for that idea?
Yeah, the more options we give our judicial officers, the better. That's why I'm vehemently opposed to mandatory sentencing. Having this one-size-fits-all approach to sentencing just doesn't work, and it has all sorts of unforeseen consequences. Each case has to be dealt with on its individual merits, and giving more options to judicial officers is the way to go. Having some form of assisted accommodation, I think, is absolutely crucial, and it would work. But the real issue, and I think you speak to most people in this room and outside, they'd say, yeah, that's a good idea once you explain it to them. You speak about other accommodation options for Rebecca, and people hearing Rebecca's story say that's outrageous. Surely we as a community can find some other form of accommodation. So I think most people would agree. It's really a matter of how you get the funding for it and how you get policymakers to agree that more options are better, and this type of further option will make us safer as a community. And you've got to put the dollar figures on it. You've got to show that it costs you $120,000 to put a person in jail each year. It costs closer to $200,000 to put someone in youth detention each year. To build accommodation like this, you have 10 beds in it, will cost whatever it is, $3 million. And over 10 years, it's going to save us as a community $17.5 million. They're rough figures. That sort of stuff is what will get Treasury officials on board, and ultimately, I suspect, we'll get policymakers on board. So you've got to do the numbers, and you've got to show that, number one, it will improve outcomes for these people. Two, it'll make us safer as a community. And three, it'll actually save money that can be spent on other things.
There's a question test just behind you.
Hi, my name's Amber from Women with Disabilities Victoria. Deborah, you mentioned something about a diagnosis had to be before someone was 18 for an intellectual disability for it to be recognised in the disability setting. Could you talk a bit more about that? I'd really like to know more. I feel like that could really extremely disadvantage particular groups of people.
Oh, it's a reference to the Disability Act. If you want to look at our report, I'll see if I can find the relevant reference. But it was I think it relates to the definition of it's the Disability Act 2006 requires intellectual disability to have been manifest before the age of 18. It's in the Disability Act, so it's legislation. It's our legislators don't necessarily understand the practicalities of life. I hate to, I'm sure present company accepted.
And I
No,
think
you'd
the
be
other-
right.
Yeah.
But we do often, as legislators, or legislators often get hung up on definitions of diagnosis because they have to do that because of funding restrictions. It's much better to focus on a person's support needs rather than because once you continually focus on diagnosis, you'll have people who don't fit into that round hole, and as a result, there'll be more and more people falling through the gaps.
And I think, Rob, what we see already is that people who, I don't take your point about falling through the gaps, but people who haven't had contact with the service system, who perhaps do have an intellectual disability, like Rebecca, they're over the age of 18. So if you haven't had contact with the system because you've been left to your own devices, lack support, you're past 18 and then you don't have that diagnosis by that time.
Well, it goes back to also the law enforcement approach to kids, vulnerable kids. And some can be quite hefty. Abuse and all that, and if wills to change here, the law enforcement has to kind of change as well.
The lady over there.
Hi, I'm Yvonne. I work in Disability Justice at the Department of Health and Human Services. So we work with that legislation you were talking about. And it's really about the definition, because if someone scores below that benchmark after they turn 18, it's usually a different course, but it also means often that people need different supports. And that's what that definition was based on originally. My question actually was about Rebecca, because I've got a client in a very similar situation. So under the Crimes and Mental Impairment Act, the department oversees the non-custodial supervision orders. And so I have a client who is at a real risk of going to jail because her order will be returned to court. She has reoffended. She's got nowhere to live. The NDIA is refusing to fund her sleepover staff. So the department is like co-funding all that stuff. But I'm really concerned about where she's going to end up. And once she comes, because prison is the only option for females we have, once she goes in there, she'll end up like Rebecca. Her behaviour will deteriorate. They'll isolate her, and there is no pathway out of there that I can see, because there is there's no facilities, I suppose, that are able to accommodate women in these situations. So I'm wondering where Rebecca went, how that went.
Well, one of a core recommendation I made in Rebecca's case was that Victoria needs to invest in secure therapeutic facilities, particularly for women, because we just don't have them. And we need to have an alternative to prison. It was actually interesting, when I look at recommendations, I don't just, come up with, this is my bright idea as the Ombudsman. I actually we're dealing with a really complex problem, and there's no doubt that Rebecca presented, and indeed all the other cases, a seriously complex problem. What I prefer to do is to actually get all the agencies around the table before I finalise my recommendations, to say, well, what do you think the answer is? So we have the Department of Justice and the Health and Human Services and Forensic Care and all those who clearly have an involvement. And we were, and I raised with them, should I be recommending, a consideration of these alternatives? And there was a broad sense from the table, and this is from the agencies, from departments, that we know what the answer is. We don't need to consider this any further. We don't need to review it. We don't need more reports on it. Actually, we need to invest in it. We need to invest in millions of dollars in actually having this facility. Now, I was very mindful when I And that's what I said. Now, when I put out the report, it was 6 weeks before the state election. So I wasn't very optimistic that I was going to get an answer from the government about spending millions of dollars on secure therapeutic facilities in time for me to publish my report. But I am following up on that. And
They didn't have time to do the polling on it.
So I did actually follow up, for the purposes of today, because I thought somebody might ask me what was happening, they're considering this as a matter of priority. So there will be an answer as to what they're doing about it, which I will certainly be reporting on. But there we are. But the other thing I think is worth highlighting, and I'm very pleased that somebody here from the NDIA, because this also highlighted one of the, I think, really difficult issues around who is the provider of last resort in these very, very complex cases. So, absolutely, but the NDIA, even if you have the dollars allocated, you can't send, dollar notes out to provide services to somebody. Who is actually going to provide the services for these highly complex people who are, we know, are very difficult to look after and to provide services for. Yeah.
Someone like that on paper, and
yeah.
go, that looks bad.
Yeah, I don't need the trouble. I'm not going to do that one. Who does that?
So I can't find, the services that you need.
And that issue of provider of last resort has been an issue that's occupied my office quite a lot, because quite often we get those people like Rebecca and there are simply no options. But I am going to have to draw today's discussion to a close. But before I do, I want to just take up a few of the issues that have been raised today. And I think most importantly is Justen. And in thanking Justen, I think we need to recognise what a number of people have said, the power of the story, the importance of hearing what someone like Justen has to say, the importance of their experience of tailoring services to meet their particular needs. That's going to go a long way. And Justen, your really critical message about early intervention and what would have made a big difference for you both early on, but when you got out, and the lack of supports there. I mean, Rob, you had a very powerful message too about the Royal Commission, and many people here will have the capacity to write to the Royal Commission and taking up these issues of forensic disability and the lack of responses. And Deborah's reports, I mean, there's a lot of recommendations in Deborah's reports that you could rely on in your submissions of things we need and that we want. And in particular, the investigation into the imprisonment of a woman found unfit to stand trial. But there are a 2015 report on the rehabilitation and reintegration of prisoners. It's got some really fantastic recommendations that we could work on as well. But I think, Rob, your other message was that if we want government to listen, we have to be able to quantify it. And that's the hard, boring work, because I think all of us know the stories, but we have to be able to justify it financially. And we have to get a lot smarter about talking to government about not just what we want, but why it makes sense, why we need to reinvest in our communities to stop this incredible pathway, the growing pathway of prison, and then you're in the cycle. Deborah, I was pleased to hear you say that there's a bit of a flattening out of the recidivism rates. Perhaps we are doing something right, but the numbers are just phenomenal of those entering prisons. Any last comments that anyone here would like to make? Justen, anything last comment you'd like to say?
Well, I said we've got an election coming up in New South Wales in a couple of months, but that's based on the funding there too. So I think, as we all said, that it's going to be more. Eventually, if nothing's done and sorted, and there's going to be a lot more prisons out there opening up, and the justice is going to keep getting full. And anyway, there's that the whole land be full of prisons, wouldn't it? Like a whole bunch of people in there, and unless the governments get their heads together and
And there's got to be a better way. I think that's your message too. Deborah or Rob, any final comment?
Oh, just the community here needs to feel emboldened to use the expertise that you have to give governments the imprimatur to go down a justice reinvestment, restorative, therapeutic, holistic approach rather than the horrible one-size-fits-all, lock them up and throw away the key approach. Governments will listen to its constituents.
Yeah, we all have a responsibility here. This is not something merely for government agencies, individuals, policymakers. This is our problem. It is our collective problem, whoever we are, wherever we are.
Would you all join me in thanking our speakers for today? Thank you.